This is the second lecture about using terminology to help understand the arbitration process. Next two terms, consolidation and joinder, are frequently confused. Consolidation refers to when two or more separate cases are combined into a single proceeding, and joinder is just where additional parties are added to an already filed proceeding. The parties can do this certainly by agreement. If they are unable to agree, the arbitration rules generally have a procedure that expedites the process. These terms should be familiar to you from your law classes, so I'm not going to spend a lot of time on them. Just note that a brief can be a pre-hearing brief before the evidence or a post-hearing brief to summarize what went on during the case. These can be very effective ways to make a case more efficient, to reduce things in writing to writing instead of taking hearing time. But on the flip side, they can also be things that extend the time, and they will also add to the cost of the arbitration because the parties will likely have to pay the arbitrator's hourly rate for reviewing these briefs. Briefs can also be at any time during the case to support a procedural motion. And a motion is simply a request to a decision maker, an arbitrator, or a judge for specific action or for the resolution of a procedural dispute. They can be made in writing or they can be made orally at a hearing. Similarly, these terms you've probably seen before. Jurisdiction, which is basically the authority for the process to go forward or the authority of the arbitrator. Locale, sometimes referred to as situs, is the place of hearing. And injunctive relief is an order requiring the subject in a case to take a specific action, or it's in order to correct a wrong. For instance, a stop work order might be a form of injunctive relief. And an interlocutory motion is a temporary, or an interlocutory order, is a temporary decision prior to a final decision on the merits. An example of an interlocutory order might be in case where there are multiple claims and an order of an arbitrator stops one of those claims from proceeding any farther until the claims on an earlier part of the case are resolved. Procedural terms, again, you've seen these before: evidence discovery, affidavit, interrogatory. Take a look at them. If you have any questions, please submit them via email. Types of arbitration awards, and these may differ slightly depending upon jurisdiction, but you'll probably see terms in a description that make them familiar to you. An interim award is a partial award which does not fully resolve a matter. A consent award is when the parties have settled the case, but they want the power of an award behind it, so they give their settlement agreement, to an arbitrator who, if he or she agrees with it, will sign it, and then it can be enforced in the same manner as if the arbitrator had heard the whole case. When it is a consent award, note that the arbitrator really can't change it. The arbitrator's choice is either to sign it or refuse to sign it. An award with no other descriptors is the full and final disposition of a matter as issued by the arbitrator. Findings of fact and conclusions of law are determinations usually made by a lawyer arbitrator, although they could be made by a non-lawyer, and they are simply that arbitrator's decision with respect to a fact that might have been in dispute, or series of facts, or a decision with respect to certain laws which have been in dispute between the parties as to how they pertain to the case. These are not frequent in arbitration. You may see them occasionally in very large and complex cases. So in summary, just keep in mind that the descriptions given above are all very general definitions, just so that you're familiar with the terminology as you go through the materials this week. It is critical to know that when you see these in a different context, they may have different meanings. Also, some of the terms may be different in different parts of the country, or different rules may use slightly different terms for the same procedure. So always make sure you read things thoroughly, and if you have a question, ask. But the primary purpose of this section, again, is just to give you some familiarity with the terms you will expect to hear in arbitration.